sort of amazing to listen to an elected representative who thinks the way we do. We don't see too much of that in Concord right now, and we don't see too much of that in Washington, D.C., so thank you, Mr. Speaker. That was wonderful. Our next speaker this morning is, for those of you who attended the big hearing in the Reps Hall, first round of House Bill 1589, universal background checks, had a chance to hear a gentleman get up and speak. None of us had met him. We hadn't, certainly I hadn't heard of him. And I sat there and listened to him talk about the meaning of words. And if words meant nothing, what did? So I'd like to ask Ian Underwood to come to the podium. Ian, like many of us, is another transplant to New Hampshire. Indiana, I believe, is your home. He's a mathematician, scientist, and inventor. Fairly all-around good guy. And the things that he's going to talk about this morning, I hope that you listen carefully, because these are things that we have to do. We cannot be afraid to name the thing. So, Ian, thank you. Good morning. Good afternoon.
Thank you. Thank you, Susan. Well, we'll see. I don't think she actually knows what I'm going to say. So in the testimony that Susan mentioned, I asked a question, which is, if this legislature is going to ignore the limits placed on it by the New Hampshire Constitution, why shouldn't individuals ignore the limits placed on them by this legislature? I thought that was a good question. And judging from the feedback that I've received, a lot of people also thought it was a good question. But judging from subsequent discussions in committee and in the House in general, it appeared to have absolutely no effect on the supporters of the bill. So I've been thinking about why that's the case and what to do about it, and I'd like to share my conclusions with you today. And I'll warn you up front, I'm going to make a suggestion, and I think some of you won't like it, but all I ask is that you think about it. And I think the more you consider it, the more sense it will make to you. I'll also make this offer. It's cold, we all have other things to do, so I'll try to be brief, but I will be happy to come and speak to anybody at any length about this subject to answer questions and objections and so on. Susan knows how to get in touch with me. Okay, so here's the suggestion. Stop making arguments about constitutionality. And I'm going to give two reasons why I think we should do this and propose an alternative. The first reason is it's not effective and it's possibly counterproductive. For some time now, the very word constitution has been ambiguous. There are really two constitutions at the federal level and in every state. We could call them the written and the oral constitutions. The written constitution is a small document. It uses plain words. It was intended to be understood by plain people without help from constitutional scholars. It contains statements like, the right of the people to keep and bear arms shall not be infringed. Simple words, not much to misunderstand there. The oral constitution, on the other hand, is a body of commentary, not unlike the Talmud, which is built up over generations, largely from judges looking not at the written constitution, but at what other judges have said. It's oral in the sense that it's not actually written down anywhere, at least in the form of statutes or constitutional clauses or anything you could look up. If it were written, the oral Second Amendment would look something like this. The limited right of an approved subset of the people to keep and bear an approved subset of arms shall only be infringed in ways that are consistent with certain balancing tests and levels of scrutiny, which the courts will invent as needed and reveal on a case-by-case basis. So I would note that HB 1589 is consistent with that Constitution, and so is SB 244, and so is the New York SAFE Act, for that matter. So I want to be clear that I'm not making a point here about right versus wrong. I'm making a point about persuasive power. And for someone to whom the Constitution means this oral Constitution, which is just about everybody who's not here today, the argument that this bill is unconstitutional in terms of persuasive power is pretty much the same as the argument, I don't like this bill. The significant difference is that when you say this bill is unconstitutional, you may inadvertently cause the person you're talking to strengthen his conviction that the oral Constitution is the Constitution and that he should stick to his guns, so to speak. Also, when push really comes to shove, I would say that you don't really buy that argument yourself. And to see that, just imagine for a moment that in a fit of electoral madness, even the written Constitution were amended to say that owning firearms is a privilege and not a right. So just imagine for a second that's happened. Would you say then that, well, it's in the Constitution, I guess that's okay? Or would you say that some issues are too important to let something like constitutionality get in the way? Yeah. I think you would, and that's exactly what sponsors of bills like HB 1589 and SB 244 are arguing right now. So, to sum up, arguing about constitutionality doesn't help, it might hurt. Please don't do it. The second reason is more subtle. A constitution creates a legislature and limits its powers. That's what a constitution is for. But there's a more basic document, the Declaration of Independence, that justifies the existence of the New Hampshire Constitution and the federal Constitution, and likewise limits their powers. That document asks and answers two fundamental questions. One, why do we have governments at all? Two, from where do governments get their power? And until you've sorted those questions out, you can't even begin to think sensibly about mechanisms for creating laws, let alone about what those laws should say. There are lots of possible answers. You can look around the world at different countries and different cultures to see ways in which other people have answered these questions. But the American answers, the answers that define America as a country are, one, governments are formed to secure rights. Two, governments derive their power by consent, that is, from delegation. These are the limits that the Declaration puts on American governments at all levels. If it's not for the purpose of securing rights, government can't do it. If it requires a power that can't be delegated, government can't do it. And these questions and their answers have to be brought to mind every time the government proposes to take some actions, because if not, having set up procedures for making laws, everything starts to look like a fit subject for law. Right? When you have a hammer, everything starts to look like a nail. And we will see legislators trying to use law for things like to do good, or to make things fair, or to promote morality, and so on, none of which have anything to do with securing rights, and none of which can be done without claiming powers that cannot be delegated. Now, the question of securing rights can be difficult to discuss rationally because currently rights and entitlements have become sort of synonymous. But the question of power is easy to understand. If you couldn't do something to your neighbor, you can't send the government to do it for you. And this brings us back to my original point, just at a different level. The authors of every constitution, federal or state, ignored the limits placed on them by the Declaration of Independence in exactly the same way that legislatures now ignore the limits placed on them by these constitutions. Same shit, different era. It's tempting to blame a lot of this on judges. Jefferson noted that the doctrine of judicial review, which is the lunatic idea that courts get to say what the law means, makes a constitution into a thing of wax, which they may twist and shape into any form they please. He was right, and judicial review explains a lot of how we got to this point. And by this point, I mean where we have to come down here year after year and plead with a government whose stated purpose is to secure our rights, to stop violating those rights. But even without judicial review, the federal Constitution and each state constitution contains, to borrow Jefferson's words again, the germ of its dissolution. That germ is the assumption of any power that cannot be delegated. It's not hard to find one. Pick up any constitution and look for the word tax. Then ask yourself if you could, as an individual, go to your neighbor's house and demand, under threat of force, that he turn over some of his money to be used for your purposes. You can't do it. So you can't send the government to do it either, unless that government is deriving the power to do it from some source other than delegation. That is, unless that government is crossing the line between delegation and conscription. And once you drop something like that into a constitution, no matter how small the transgression, no matter how urgent or noble the goal, it's like putting a cancer cell into a body. How much damage can one little cell do? I don't think I need to spell that out for you. So here it is in a nutshell. A constitution that assumes the power to take someone else's money in your name also assumes the power to take your guns in their name. Because they assume powers that can't be delegated, the federal and state constitutions are ultimately unsuitable as foundations for liberty, and I would urge you not to build your arguments on them. So, I promised an alternative. I've already really mentioned it. I suggested that when thinking about any law, you can ask yourself, could I do this to my neighbor? If not, how could I send a government to do it for me? And this is the question that I suggest you ask your representatives whenever they propose that government at any level do nearly anything at all for nearly any reason. Sir, madam, you want to be respectful. Constitutions may only authorize and governments may only exercise powers that can be delegated to them. The power that you propose to exercise could not possibly be delegated by any person. So from where else exactly do you claim to get it? Thank you.